I could have your attention, please. I'm Grant Buckner, the clerk of the Supreme Court. On behalf of the court, I want to welcome everyone to argument this morning. Just a couple of things before we begin. First, we're not going to start right at 9:30. We're having some issues with our streaming equipment. We want to make sure that those in the office or at home and want to watch can do so. And so we think we'll have that up and running in about 5 minutes or so. But we're not going to start right at 9:30. If you need to exit during the court session, please use one of the back doors. The marshals are going to shut that door in just a moment. Check your phone. If you have a laptop, check it as well. Make sure it's turned on silent now. And as soon as we can get that equipment up, we're going to start court. And we want to welcome you and thank you for being here. If you want to take a picture, you're welcome to do that either now or after the session, but please not during the session. Thank you.
Good morning, everyone. Our first case this morning is North Carolina Department of Revenue versus Wireless Center of North Carolina, Inc. And we'll hear from the appellant.
May it please the court. I am Stanton Geller with Culp, Elliott & Carpenter, representing Wireless Center of North Carolina, Inc., the appellant. I ask to reserve 8 minutes for rebuttal, please. There are two key issues in this case. One, what is a prepaid card, RTR, store value card, as those terms are used? And two, how to interpret both the prepaid wireless calling service statute, PWCS, and the sales tax treatment of gift cards. Much of the history of the case in the record, the briefing before this court, and the amicus brief has been dedicated to explaining this technology. Prepaid cards are a technology to add funds to a customer's account with Boost. It is in no way, shape, or form mobile telecommunication services. Further, prepaid card is just one of many ways customers can add funds to their Boost account. The explanation provided by Appellant and accepted by the ALJ summed it up well. Replenishments, whether a card or electronic, are used to add funds to a customer's account to be used to purchase products and services and are not limited to mobile telecommunication services. Customers can also independently replenish their account online. Hopefully, it is clear that funds can be spent on any products and services at customers' choosing. That includes non-taxable items such as internet, which is covered by federal law with respect to its taxability or non-taxability. At trial, both Appellant and Appellee put on evidence to describe prepaid cards. The ALJ adopted Appellant's explanation both as to what a prepaid card is and that it operates like a gift card. The ALJ further agreed that funds could be used to purchase any products and services and not tied to mobile telecommunication services. It is clear in the trial transcript and in the opinion that the ALJ was not impressed with the Appellee's case, for it lacked evidence, over-reliance on third-party agreements, lack of due diligence, failing to use proper procedures, did not use the best information available, and acting arbitrarily and capriciously. These are all
Counsel, can you help me distinguish between what was going on prior to, what was it, September the 9th of 2017, and then after that? It seems to me that you're lauding the ALJ's decision, and yet you also appealed that portion.
I agree with the ALJ's decision that that prepaid cards are gift cards. I agree with that. The one distinction is that the technology of the prepaid cards was the same during the entire audit period. That was my one exception to the matter. Otherwise, I do agree that prepaid cards are not PWCSs, and it's not tied, the purchases are not tied to mobile telecommunication services. So I otherwise agree that they should be treated as gift cards. That was a proper ruling.
But you did appeal with regard to the what the ALJ had decided with regard to the first portion, the period 1, if you will, as
Yes.
opposed to period 2.
I think that with respect to the law, the law was correct, but Boost, the letter that was sent out to the stores did not change the law and the functionality of the prepaid cards. And I think that while I agree that the prepaid cards are treated as gift cards, I think that it should be applied to the entire audit period, not just when that letter was sent to Boost store owners. The ALJ saw flaws solely with determining the nature of prepaid cards based on third-party boilerplate agreements. Hopefully, the amicus brief has added further clarity on what a prepaid card is and how the technology works. The second key is interpreting the law is applied to prepaid card technology.
Excuse me, before you move on, I'd like to explore the third-party agreements or the agreement between your client and Sprint or Boost or whoever the particular party is. Your friends on the other side make a strong argument that we should be considering that. Could you explain why, what your position is in that regard?
One, the agreement is a boilerplate agreement that's used under many circumstances. I would use the position of the state actually as far as what the law is. The law is determining what is actually going on and not necessarily reading a contract. For instance, there's a provision in that agreement that says my client shall collect sales tax on products, capital P products. Well, if my client sold other taxable items such as services and didn't collect sales tax and then went to the state and said, well, look, this agreement said I only had to collect tax on products, that's what the agreement would say, the state would in essence say, too bad, that's not the law. The law is you were supposed to collect these taxable items as a retailer on these matters. The agreement is again, a boilerplate agreement. It has its flaws. The definition of RTR and airtime is circular. If you read the agreement, also the agreement can be unilaterally amended by Actify, the master service. It's a classic boilerplate agreement, and I am focused on what is actually the technology and applying what is actually the technology to the law. That is my focus.
And if I might follow up, what got my attention were some of the language you mentioned, airtime, and some of the other words that were used to describe what your client would be selling. They sounded more like what was going on maybe in 2007 when the statute was first enacted, and that this particular contract has not been updated. And so I'm struggling with how to, what to do with that language in the context of the statute, which is the law, and the technology and where it's moved today. So if you could comment on that, that would be helpful.
I would agree that the agreement is outdated and geared toward older technology. It is crystal clear that funds are going to a customer's account, not airtime, not mobile telecommunication services. Airtime is not a form of consideration. You don't spend airtime to buy a phone charger. It is fungible funds that are going to a customer's account. So I agree that the agreement is outdated with older technologies such as prepaid minute cards, which is a PWCS, a prepaid minute card. But this is a different animal. And I think one of the issues with the case is trying to explain this different animal with an old, outdated agreement, boilerplate agreement.
But it is, just for clarity, it is the agreement that was in effect at the time that of the audits. Is
That's
that
correct.
And then one other follow-up. You mentioned that these are fungible. This is fungible consideration. In my mind, I saw your comparison to a Visa gift card. And so if I go into a retail store and buy a Visa gift card, I can turn around immediately and it's like money.
Right.
I don't have to have a Visa account. I don't have to have a credit card with them. Can you explain to me how there is a difference between this Boost card, because you do have to have this account or this contract with the supplier. I'm trying to accept your analogy, but there are some distinctions. So could you explain that and tell me your position there?
I think the point with a Visa gift card is that you could make any number of purchases in the future, and that the same with a Boost card. If it goes onto a Boost account, it's the exact same thing. It's funds that you could use on any number of goods and services not tied to telecommunication services. So in effect, if you expand the reading of the statute to say it's a possibility to buy telecommunication services, you just brought in all these gift cards, including Visa gift. I have the possibility to purchase these telecommunication services. So I think that's the distinction.
And so if I put consideration money into my Boost account, may I spend it anywhere else, or does it have to be spent at a Sprint store?
It's spent with Boost.
With Boost. Thank you.
Yep. The second key issue is interpretation of the law as applied to prepaid card technology. For clarity, our position is that prepaid cards should be treated like gift cards and not PWCSs. The trial court agreed and further stated Appellee provided no evidence that the tax was for a service that is sold in conjunction with telecommunication services. The trial court also pointed out the inequitable nature of Appellee's position on the law.
So you're saying that the trial court agreed, and yet the trial court ruled against your client in period 1. Reconcile that for me.
I think fundamentally, with respect to the technology, with respect to how it works with Boost as gift cards, I agree with that ruling and that determination. I think that relying on
Which ruling and which determination?
that prepaid cards are akin to gift cards, are treated as gift cards. I think that the letter that Boost is telling its store owners that now we're collecting sales tax, the technology is the same. And I agree with the technology. The technology is same throughout the audit period, before September 8th in that period.
So where did the administrative law judge go wrong in period 1?
I think in applying that the technology, an understanding of the technology, I think there should have been less relevance that they should have been treated as gift cards based on that letter to the stores, and it should have been applied for the entire audit period, for the technology starting from before the letter until after the period. The technology is the same in adding funds to a customer's account to use as they please. That's where the disagreement was with the ruling. With respect to the PWCs, the history starts in 2001. The statute was designed to tax prepaid minute cards. This is outdated technology, and I would agree that minute cards are PWCSs if sold. The current statute has a requirement of meeting 3 elements. The first is authorizes the purchase of mobile telecommunication services either exclusively or in conjunction with other services. Neither mobile telecommunication service nor any other purchase is authorized until a customer makes that selection after funds are added to their account. Exclusive.
You imagine that what the legislature was getting at there, like if we assume what's going on here is that when you have a cell phone service and where you've just contracted with the carrier and you say, give me service and you can bill me. When you get your bill, there's going to be a sales tax item there in your bill for the service. And the concern was, well, when people buy the prepaid cards, they're not paying sales tax. But then when you're using the card for the minutes, the carrier's not charging you any sales tax. So they're evading sales tax on this particular. So they tried to find a way to say, well, we want to impose the sales tax somewhere. If you assume that that's what the intent of the legislature here, you can see a difference between like a Visa gift card and these cards, because couldn't the provider, so Boost here, just say, oh, we don't take Visa? So it might check a lot of the boxes, but it doesn't actually authorize you in sort of a contractual sense to be able to use it. But when you buy the Boost Mobile prepaid card, you have a contractual right to be able to deposit that value and get the credits that you can then use for the various things with them. And isn't that the authorizing the purchase of mobile telecommunication service? Because Boost can't say no when you buy their own card. What's wrong with that?
Well, if someone adds $30 to their account and the cheapest wireless plan is $50, what's authorized? I mean, Boost isn't going to authorize it. There is a step there to authorize that transaction, and it's an important one. It doesn't automatically happen. And with respect to the legislative intent, I would agree that there's there's purchase that no one's collecting sales tax because it's prepaid minutes card. But this is exactly the opposite. It is stored on a Boost account and tracked diligently by Boost. They submit sales tax returns in North Carolina, itemized on sales that are subject to sales tax and don't collect it on items that aren't subject to sales tax, like internet service. So it's a completely different animal than the prepaid minute cards of old and an outdated technology. And
But if you're looking at what Boost is tracking, apparently during period 1, they said, retailer, that's up to you. But then during period 2, they said, no, we're going to start being responsible for the taxes. How do you reconcile that?
I think it's Boost's responsibility as a retailer to collect sales tax on sales it's making at retail in North Carolina, whether at the beginning of the audit period or the end of the audit period. That is their responsibility as a
Why can't they defer that or transfer that responsibility contractually?
No, because if we argued, the taxpayers argue that I don't owe something because I contracted, someone else pays it, the state is going to come in and say, we don't care, you're the retailer. And that's why we have laws identifying the people's responsibility for paying sales tax. They're going to say, you are the retailer, it's your responsibility to collect sales at retail for goods and services sold subject to sales tax.
Would you agree that under that contract then, that if Boost were to to pay the tax during period one, that they would have a contractual right to go to your client and say, you need to reimburse us?
Boost would ask for reimbursement?
Yeah.
Is that, well, no, not if it's their responsibility to collect sales tax as a retailer.
So contractually, they can't say to your client, ultimately, sales tax are your responsibility.
I mean, I think you're asking, can Boost ask a client to collect sales tax? If there is an agency relationship, they could ask to collect sales tax, but if they're an agent, if they're an agent of Boost, then it's the agency principal, and that they would both be responsible for the sales tax. It would just be a relationship of collecting it. But still, it is the ultimate responsibility of the retailer to collect sales tax at retail sales to customers. And it's Boost is the retailer of sales of goods and services to the public as they spend money on their account with Boost Mobile.
Well, if Boost is a retailer, how would you characterize what your client is? Are they simply a salesperson?
My client simply facilitates transferring funds to customer accounts. There's no inventorying of this method. It's not an inventory. They get paid a commission on facilitating the sales. Is facilitating a transfer of funds, a sale to funds to Boost a sale? I would say no, it is not. It is an act of transferring funds, and they get paid a commission for
Let me ask you about that, because I think, well, let me frame it this way. Do you agree that there's no statute, there's no state law that says gift cards are not subject to sales tax? Do you agree with me about that?
Well, gift tax is used in statute, and there is a clear North Carolina admin code that specifically says that gift cards are not subject to sales tax under 105-64 sales tax route. So
right, but my point is that's because they're inferring that from the structure of the actual tax code, the actual general statutes. But there's no law, there's no general statute that says you don't pay sales tax on a gift card, right?
Well, the item subject to sales tax is enumerated, and it's not part of that enumerated
That's what I'm
list.
getting at.
Yes.
But it could be.
If they
Because
wanted-
couldn't the legislature
Yes.
make a policy decision and say, you know what, it's too much trouble to try to chase it down further. We just want to get the sales tax when you buy the gift card because we know you're going to use the gift card to later buy something that's subject
Absolutely.
to sales tax.
Absolutely.
But that's not what we do with gift cards. But I think what we're going to hear from your friend is the legislature just made a policy decision to carve out one category of gift cards, which are prepaid wireless cards, and say, no, but we are going to charge it here, even though we don't treat other gift cards the same way, which is a line drawing that the General Assembly properly could make if they wanted. So what's your response to that?
I don't think PWCSs are a gift card at all, period. I mean, there's three elements to that statute that you have to meet. It's exclusively or in conjunction, mobile telecommunication services, exclusive in conjunction with those paid in advance, known in predetermined units or dollars that declines in use and known on a continuous basis. I would say that is a very narrowly drafted statute designed for a specific target technology, and it is the prepaid minute cards of old back in 2001.
I understand, but that's a different, and I think that is your stronger argument. I just wanted to clarify that, because the argument you're making now is that the cards that your client sells don't meet this statutory definition, or that there's enough ambiguity in this definition that your client as a taxpayer wins and doesn't have to pay the sales tax.
Well, I want to be...
That's a different argument than saying, oh, gift cards aren't taxable, this is like a gift card, so these shouldn't be taxable either. Do you see the contrast I'm drawing?
Yeah, and I hope I hope I clarify, the primary argument is that these are gift cards and should be treated as such, period. That's the primary argument, so I hope I can clarify that.
Right. Well, I guess what I'm saying, though, is I think your other argument, which is whatever these things are, they don't meet 105, 164.3 because they just don't meet the plain language or because there's a bunch of ambiguity in what exactly this is getting at.
Well, I think,
So
I think.
why don't you emphasize why you think that's the case? That
Well, we're focusing on that statute is because the state's focusing on that statute and saying this is the animal. This is a prepaid wireless calling services. So that, I am focusing on that statute to say, no, it's not. It doesn't meet the statutory definition. And I think secondarily, if there's any doubt as to whether it's a gift card, and I don't have doubt, I think it's a gift card. But if there is any doubt, then I would say we need to look at the law, the ambiguity in the law with respect to tax statutes, and as briefed in as described in the brief, if it's ambiguous and can be construed two different ways, it should be in favor of the taxpayer because of that ambiguity. So the primary argument is it is a gift card, but if there's doubt that if it is a gift card, I would submit there is a strong ambiguity in law. And not just that, we now have 2 ALJs that said that these are akin to a gift card. You have Boost, you have Sprint, you now have Dish Network, countless other store owners in similar positions as my client, all saying these are treated as gift cards, and they are not PWCSs. But one thing that I've touched on.
I guess, just to take you back, and the reason you're saying they're not PWCSs is you're saying because whatever they are, you call them gift cards, it doesn't matter what they are. When you tick down the statutory criteria, they don't meet those criteria, and that's why you're saying the cards don't fall within the statute. And you're saying your key argument is because it doesn't authorize the purchase of a mobile telecommunication service because you take the value that's on this card and you deposit it into another place, either through an app or the digital kiosk, and then it becomes some sort of usable credit that you can use to purchase either mobile telecommunication service or internet service or something else. That's your argument.
That is correct.
And because there's that step in there that with the prepaid minutes, the old cards that didn't exist, what your client sells doesn't fall within this statute. That's your argument.
Correct.
Why is that not a right?
I mean, if we're gonna, what is a right? Is money in my pocket a credit card, a Visa gift card? Is that a right? I don't think that's where the focus is. I think the focus is on the 3 elements of telecommunication services with respect to that PWCS.
Why wouldn't, or how should we interpret the statute that specifically calls this thing that's taxable a right?
Well, a right is for sure and certain. And as I was saying, the example I've given is if you put $30 on a Boost and the cheapest wireless plan is $50, you don't have a right.
Not to a particular product, but according to what you've told me before, you might have a right to buy a $3 product.
I think there is, if with a prepaid card, there is an intangible right to that card in itself. But what does that mean? What is that intangible right? And I think that's where you go into the 3 elements. It's a right that meets all 3 of these elements, and you go down each one of these elements, and does it meet it? And I submit, no, it does not meet these elements as described under the PWCS. I see that my time is 6 minutes. I'd like to reserve the remainder, please. Thank you.
Thank you, counsel. We'll hear from the appellee.
Good morning. May it please the court. My name is Tania Laporte Reveron, and I represent the Department of Revenue. This is a case about statutory interpretation of the statute in the Sales and Use Tax Act that makes the prepaid wireless services taxable in North Carolina. The business court's order and opinion on this interpretation is correct, at least for 4 reasons. The product sold by Appellant fits the definition of the statute because it is a right that authorizes a later purchase. The product did not change during the entire period. Appellant was the retailer of the product, and appellant is liable for the payment of the tax for the entire period. Here is the
I understand your argument to be on the Internet Tax Freedom Act issue, that the business court, if you were to go back in time and bring that, the business court say, what are you even talking about? Because that was never an issue that was argued to the business court, anything concerning the Internet Tax Freedom Act. That's what I understand your argument to be. So you say it's waived now. It may have come up in appeal later, but it was never brought up at OAH or before the business court, and now it's too late.
Certainly, it wasn't brought up by appellant at the Office of Administrative Hearings. Even if this court would like to explore under the issue, here's the thing. This transaction that the department issued an assessment on is on the sale of the right, not on purchases that are made after by the customer. The customer, once it acquires the right, it can do whatever it wants with the right. The customer can acquire a ticket for a concert and not go to the concert. That's irrelevant. The use of the product is irrelevant after the customer acquired it. What is taxable and the assessment that was issued by the department for these years was on the sales of these replenishments.
Just to clarify my question, I guess I didn't do a good job of articulating it, but I'm trying to figure out, I know you assert that there was never an Internet Tax Freedom issue that came up at OAH, but did it come up in the business court?
I believe my recall of the transcript is that appellant tried to bring it, but we raised the objection that it wasn't brought up to the lower court, and then it was barred from review.
Because what I'm trying to figure out is, let me just give you a hypothetical. Suppose I'm someone who has a Boost mobile smartphone, but I have no friends, I don't call, I have no one in my contacts, I don't text anybody. I use the smartphone to get internet access because I use TikTok and whatever. That's where I talk to my friends. So I go into a retailer like Wireless Center. I buy this prepaid wireless card knowing that I'm buying it because I'm going to use this credit to purchase internet time through this provider. Doesn't that fit all the criteria of the Internet Tax Freedom Act? And if I'm charged a sales tax to buy those credits and use them for that purpose, that would be taxing my internet access.
The answer would be no, because what your owner would be buying at the store, at the retailer store, is a right. At the moment that your owner enters the store, your owner is not purchasing internet. And what the Freedom Internet Tax Act forbids is the state to impose a tax on the purchase, on that direct purchase of internet. But internet is not what the appellant is selling. And your owner made a choice of use the product to access internet. But the reality is that the product that your owner is acquiring, your owner is entitled to acquire it because your owner has to have a personal telephone number with Sprint's network. Your owner is purchasing a right. What your owner does with that right, if it has friends or no friends, is irrelevant to the statute.
But wouldn't the problem be then that I mean, if the purpose of the Internet Tax Freedom Act is that they don't want you taxing payments to access the internet at all, you would think that Congress would want it to cover a scenario of the people who have to buy it in prepaid chunks and not just have an internet service provider that they pay monthly. And I imagine that there are a number of people who use these cards for that purpose. And they are effectively having to pay sales tax on their internet access because this is the only way they can pay for internet access. And so I understand your point that you could always buy it and change your mind and say, actually, I'm going to use it to buy the mobile cell phone service. So it doesn't have to be. But my point is, I can definitely see Congress saying, but we intended to cover that. If your intent is to buy it, to use it for the internet, you can't charge the sales tax, and you have. So the argument would be it preempts the scheme as we have it now, and instead we, the state of North Carolina, would have to say, well, we'll charge the sales tax once you know what you're going to do with it, and which is what Boost Sprint started to do in the second half of this taxable period, right? They just collect the tax themselves. So the reason I'm asking you this is if we have a concern that there could be this preemption problem for part of the scope of the act, does that create an ambiguity? Because we, of course, wouldn't want to construe a statute in a way that part of it's unconstitutional. And you'll probably guess where I'm getting at, because if we end up finding any ambiguity in the statute, you know, you lose, the government loses, the taxpayer wins. So what's your response to that?
The response is no. I believe in the brief, it was stated that the Internet Tax Freedom Act has a couple of exceptions, and one is the bundle transaction. What is the provider of the Internet itself offering? And the statute is actually on the purchase, not on the intent of the customer, what it's going to do with the Internet. And second, as being more locally, we have to remember that what the statute taxes is the sale of this right that authorizes the purchase of mobile telecommunications services. The statute specifically says that it's taxable at the point of sale and not at the point of use. It was the intent of the General Assembly that what matters is the sale, not what the customer ended up using it to, or for. Excuse me.
So help me square this situation, counsel. With Justice Dietz's example, he intends to use purely the gift card or the prepaid wireless services card for entirely non-taxable use, right? But it is subject to tax under the statute. Is that, do I understand it correctly?
Yes, Your
In
Honor.
a very rudimentary way, right?
Yes, Your Honor. And what the statute is based on is not on the intent that the customer pretends to give to a product that is very exclusive to every customer, right? Like, again, the example of the concert. What if I decide not to go? I mean, or other situations like that. The intent of the statute is definitely on the purchase itself, once the purchase is made. What the customer did after it acquired the product, let's say I want to buy a shirt, and instead of the shirt, I'm putting it on myself, I decide to dress a doll with it. That's not what is relevant. It's the taxable transaction. Another thing is that this taxable transaction, it is sourced, if the right is delivered to the customer at the business location of the seller, it is sourced to that business location, and is taxable at the general rate that is in effect at the moment of that sale. What happens with that use after, it can be in another location that is not North Carolina. It can be at a certain point in time that is another rate. The intent of the General Assembly was that this transaction, the sale of the right, it is taxed at the moment of sale because it's prepaid. We don't want the money to go away, and it's sourced to where it was delivered.
Right, but even though I acquire it with the intent to use it for something that would ordinarily not be subject to tax, the right here is subject to tax, regardless of use. Is that?
What the statute does contemplate on intent is only that the right has to authorize the purchase of telecommunications services.
So could I go to Walmart and purchase prepaid telephone service and go to the front of the store, buy a Visa gift card with the sole intent to purchase taxable wireless service, right? And that not be subject to the same tax?
Under this tax, under the statute 164.4D, what is taxable is the right that this right authorizes the purchase of a mobile telecommunications service.
Right, so.
This right.
So walk me through this. I purchased the Visa gift card in the front of Walmart. My intent is to walk to the back of the store and purchase prepaid wireless services in the electronics department. Why does that Visa gift card not authorize the purchase of mobile telecommunication services, either exclusively or in conjunction with something else? Right? It's paid for in advance, and it's sold in predetermined here dollars for a dollar value that declines with a known use. So why is the right on one different from the right on the Visa gift card? I am authorized to use that card to purchase prepaid wireless services. How's that different?
I believe that the intent of the General Assembly was directed on these specific products that are specifically for that. And in this case specifically, the customer has to have a personal telephone number. In the case of the hypothetical example that Justice Berger is giving me, the customer might not have that personal telephone number before with Sprint, might acquire it later, who knows?
Let's assume they do. Let's assume they have a phone they purchased through Walmart. They go to the front of the store, they buy the Visa gift card. I'm going to buy additional minutes on my phone. They walk to the back, they put additional minutes. Why is that different under the statute? Why is that right different just because I bought a Visa card and not a prepaid wireless card through Boost?
It is not intended to, the way that I see it, Your Honor. I believe if the Visa gift card can be used to acquire a wide array of goods or services that doesn't have to deal with telecommunication services, it is not what it is intended on this statute specifically that was which sales were assessed against appellant.
Right, but if we look at the plain language of the statute, right, that's where we glean intent, right? And you said, well, the Visa gift card could be combined with other services or uses perhaps, but the statute apparently contemplates that. It says either exclusively or in conjunction with other services. I'm struggling with why that's not ambiguous or why it's not so plain that it would cover the Visa gift card.
If we read the statute on it as a whole, reading subsections one related to the other, this is the definition of prepaid wireless calling service of this taxable item, which is telecommunication service. That includes prepaid wireless calling service. So we have to start with that phrase itself. What are we defining? We are defining prepaid wireless calling service. I believe that is why it's different.
Does Boost have to accept the Visa gift card?
Thank you for your question, Justice Allen, and that answer is not on the record. However, my belief is no, because as part of the agreements that were binding for retailer, pretty much the agreements only state the replenishments as the way or gateway to get into the Sprint's network. It doesn't mention other products. It's the real-time replenishments that entitles the customer that goes into the appellant stores to enter and acquire services inside Sprint's network.
If a customer purchases the RTRs, can Boost refuse to allow them to use it, the RTRs on cell phone services?
I believe the answer will be no, because it is a right, and at least pursuant to the agreement that which entitled appellant to sell this product. It definitely says by acquiring the replenishments, the customer will be able to access Sprint's services.
But the RTRs can also be used for other products, right? Like handsets or a variety of cell phone cases, other products.
In the period of this assessment, that was from 2016 to 2018, and the record of this case, which is pretty much to that effect based on the retailer agreements and the replenishment programs, What it says about the RTR is that once it is acquired, it can be used to access Sprint's services, and services are expressly defined in here as the prepaid plans, customer services, and Sprint's network. Only 3 things are in the record of this case.
So so your position is the RTRs throughout the entire period could never be used for anything else, no products, the only thing you could use them for was the cellular service?
Yes, Your Honor, the agreements rule on that issue.
Or
of
internet,
what can be
or internet service, right?
networks, the agreements rule on that issue.
Do you have a question?
And while you're on,
I'm sorry, go ahead.
no, while you're on the topic of the contract, I think you just cited to it, what are we to make of that? Could you expand just a little bit about the language that's in that contract and also the argument that you're making that in some regard cabins in or defines the statute and how it interplays?
Yes. Thank you for your question, Your Honor, because that was the next step. What the customer acquires when it enters into the Appellant store are replenishments, are not cards. Appellant has to have his personal telephone number, give it to the clerk, or to, the customer has to have his personal telephone number, give it to the clerk or to Appellant. The customer has to pay the amount of the replenishment, and the account of the customer at that moment gets immediately replenished with the value of the replenishment. And with that value, the customer can then do what the customer pleases. It can purchase wireless plans or other services as defined in the agreement. How does this fit the statute? The statute, first of all, is not an item in the prepaid wireless calling service, which is the taxable item for purposes of the argument. In fact, it is not an item. It is not a service. It is not the wireless service. It is a right. It is first defined as a right. And this right has to comply with the other 3 requirements. It has to authorize the purchase of mobile services, be paid for in advance, and be paid for in predetermined units or dollars that declines with use. Now, how does this product fits into this statute? The agreements entered by Appellant clearly state that by purchasing real-time replenishment prepaid call credits, customers will be able to access Boost mobile services. And in fact, one of the affidavits that was subject of issue, but it is part of the record, and it was also considered by the business court, admits by Sprint to that effect. The replenishments are intangible rights that authorizes the customer to make later purchases in Sprint's network.
How do you counter your friend on the other side's argument that these are just boilerplate boilerplate contracts and we should ignore them, that they're out of date, I believe? I think I'm correct. I think I'm quoting him correctly, and if not, he'll correct me in just a few minutes.
The agreements are what entitle Appellant to sell the replenishments in its stores. For the department's effect, they are enforceable, and they were provided by Appellant during the audit period. It is his entitlement. The agreements are his entitlement to sell these products.
So before your time runs out, can I ask you about the September 2017 forward period? So this is the ruling in which the taxpayer, in which your client lost, the taxpayer won in front of the ALJ. Mm-hmm. As I understand the ALJ's reasoning, it's essentially that you have a burden of production. There's a presumption that tax assessment is correct, that benefits the state. But it's a rebuttable presumption. If I understand the ALJ's reasoning, it's that here there's an affidavit from a tax lawyer at Sprint, which is Boost, and then this letter. that when combined together show that from September 8th, 2017 forward, maybe because this was such a hassle to figure all this out, they just said, we'll collect sales tax when you use the credit to buy the cellular service time. And then the ALJ said to the government, is that true? Did Sprint/Boost pay sales tax on this? Because that would be double taxation. And the state said, well, we're not going to tell you, Your Honor. And so the ALJ then said, well, then I guess the taxpayer rebutted the presumption. What's wrong with that? That seems to me to be a fairly well-reasoned position from the ALJ. I mean, if the government's the one that has the information, if they don't want to give it up, they lose. What's wrong with that?
We have two separate issues here. Let me first address the statement that the government doesn't want to give it up. First, there are privacy statutes that forbids the department from revealing tax information, payments, or lack of payments made by another taxpayer. That could have been solved by appellant seeking an order to order the department to do the disclosure. That did not happen in this case. However, the record on this case notes, and it was the decision of the business court when it reviewed de novo and under the whole record test, this record, that even that affidavit and that letter issued by Sprint after the end of the audit period noted that even if Boost or Sprint made payments on something, there was no way for them, for Sprint, to track those payments back to the responsibility of appellant because they were agnostic as to from where or from when these replenishments were sold to the customers. And second, the record at the Office of Administrative Hearings states that they were, in fact, asked for the appellant no payments made on his account for his tax liability for the period at issue. An appellant admitted that fact, that he made no remittances of this tax to the department. Now, let me address the other issue here. Let's not forget, if Boost actually paid something, if it was a given fact that Boost or Sprint remitted X amount of dollars to the department, that payment was not the payment of this tax. Why? Because this tax is a tax that is imposed on the sale of the right at the general rate at that moment of that sale and sourced to the location where the sale took place. And if Boost collected something from its customers, which, right, we don't know, it was objected under the hearsay exception, but even if it happened, we don't know at what time, at what point in time was that tax collected by Boost from the customers. Where did it source it to? These sales that takes place at the locations of the appellant happen in its 6 stores in North Carolina. We don't know where Boost or Sprint sourced these sales of services, which is the sale that happened with the use of the right. It might have well been to Tennessee or South Carolina, or it might have been to North Carolina at another rate. That, if it happened, was another transaction. It is not the transaction that is taxable under 164.4.
And I'm following your argument, but what just has occurred to me, you've talked about the intent of the legislature. Are we to accept that the legislature, in setting up this taxation of a right, knowing that it might be used for various things, that they have unwittingly or intentionally set up a situation where there's a significant potential for double taxation?
The answer is no, because the General Assembly specifically stated in I believe it's in 164.4, that these prepaid wireless service is taxable at the point of sale, and specifically said that is not taxable at the point of use, and that is not taxable as a telecommunication.
But in today's world, that's not what's going on, because when these credits are actually used in a retail setting, then some of the products are taxed. The headphones, a new phone or whatever. And so while they may have said that in 2007, I think maybe this even goes back to 2001 when it was just a wireless card, a card for minutes. There's a much more complicated fact situation here. Can you help me get comfortable with that?
From 2016 to 2018 and person to the agreements, what was sold was the services that we described before, at least for this assessment. And if the statute didn't change, but Sprint wanted to change its business model, then that is a problem of Sprint to resolve with the General Assembly. The statute remains unaltered, and the department has to, by law, enforce the statute. The statute commands that a sales tax is paid at the point of sale of the right. If a developer of the product doesn't like the statute, it needs to go to the General Assembly to fix it.
And the
But
General Assembly
the fever is not in the statute.
The General Assembly did fix it and repeal this provision then, right?
My belief and what is in the record is that the taxation of this kind of service was always taxable at the point of sale. In 2001, it said so, and in 2001, I believe that the record page establishes the word that it was limited to only. The right to purchase was limited to mobile services. In 2006, when the statute was amended, it changed it to say a right that authorizes the purchase of mobile telecommunication services, comma, either exclusively or in conjunction with other services.
But my question
Because-
was, and then that language is completely repealed from the tax code now, right?
That one is what?
Is completely repealed from the tax code now. In other words, this language doesn't exist in the current tax code. Am I right about that?
Your Honor, I honestly
Well,
don't know.
let me get
I
to
was waiting for the 2016 to 2018.
Okay, well, let me get to the reason I wanted to ask that question. I know your time is running out, but I can see the strongest argument for your friend to be, when you combine all this together, so the double taxation point that Justice Behringer is making, that we know that Boost Sprint, because it just was having trouble figuring this out, just said, we're going to charge sales tax on all of this. You have this possibility that what the plain text says is conflicting with the federal law because it's taxing people that buy their internet time in chunks instead of being able to get billed from their internet service provider. And then you have this question about, is the actual functionality of how this works, depositing the credits into this app and then using the app to actually buy the mobile technology, slightly different than the wording of the statute. And I think your friend's saying add it all together, and there's enough ambiguity here that we're just not sure if the legislature really got at what they were trying to get at in the statute. And if that happens, and we're not really sure what they're trying to do, the taxpayer wins. So why is that? Why are we not in that there's enough here to make it ambiguous scenario?
Because the statute is very clear. I think the language of the statute says that it is prepaid, pre-tax, prepaid wireless calling service. Right, this happens before the customer acquires the service plan. And I believe this is the same, it is correct now, Your Honor. It is, to my belief, the same language. There were a couple of tweaks at the end. In the last 5 seconds, I have this pen. If I add insulin to this pen, which is non-taxable, I still have to pay tax on the pen.
Thank you, counsel. Rebuttal?
Thank you, Your Honor. One point, and I apologize if I did not hear this correctly, but it sounded like that a customer absolutely had to purchase mobile telecommunication services as part of a prepaid card, if I heard that correctly. That's absolutely not the case. It's funds that go on a Boost mobile account. There's no requirement to purchase mobile telecommunication services, period, full stop.
So what else could they purchase with that credit?
They could purchase phone chargers, digital games, insurance, internet, products that don't even have wireless technology to it, like iPads, a complete array of services like you would think at any other store you could buy with those funds. And I'll also point out, and I appreciate the question, products. This is another example that this statute is gauged towards an old technology. The word product isn't even used in the statute. It isn't even contemplated in the statute. You could use all your funds to buy products on the store.
Counsel, on that, and I'm sorry, on that point, is it possible to purchase one of these prepaid wireless calling service cards under the statute, be subject to tax by the department, walk into a Boost Mobile store and buy an iPad, a charger?
That is absolutely not my understanding. That is a different, again, this is prepaid minutes under the definition under my interpretation of a PWCS, it's minutes to be used either in units or dollar amounts, like 100 minutes or $100 worth of minutes. You don't barter minutes to buy products at the store. That's not how it works. There is clear double taxation under the state's policy, and just as a thought exercise.
Sorry, just to be clear, what you're saying is PWCS is not what was being sold here.
Exactly.
It was the RTR.
100%.
Right, so then the same question about I think that my colleague was about to ask about the RTRs. You could purchase the RTRs and go into a Boost store and buy an iPad.
If it's a physical card, yes, and if it's electronic transfer, the funds go to the customer's account to be used as the customer pleases.
And so you would be taxed again. If you were taxed when you purchased the RTRs, you would be taxed again when you purchased the iPad.
That's exactly right, thank you. It absolutely leads to double taxation. And let's just, as a thought exercise, let's say there's $30 on an account that is supplied by a prepaid card. But then you want to buy something for $50. So then the customer adds $20 via the website with a Visa gift card or credit card. So that to almost avoid double taxation, you would have a double book of the funds that were from the prepaid cards and then the funds from the credit cards. That frankly would be a ridiculous exercise in trying to keep up with sales tax law, and I don't think that was the intent of the legislation. I think that.
And I pointed out to your friend, so you might use it to buy some other physical product where Boost/Sprint needs to charge you sales tax on the iPad.
Right.
You could also use it to buy internet time, in which case you just paid sales tax on your purchase of internet time. I assume that's and you're not saying that makes it unconstitutional, you're just saying we shouldn't construe the statute to cover that kind of conduct because you would run into a preemption problem with federal law. Something you can't waive that argument, it's just a canon of construction. Do you agree with that?
I agree, and internet was brought up at trial. The affidavit explicitly provided that you could buy internet service. It's in the affidavit. It's preserved. The issue of buying internet is preserved. It was in the trial as far as evidence. So it has been an issue. Do I think we need to get into the supremacy clause? I don't think so. I think the statute is clear. But I think to go back to your example of treating people differently, so a North Carolinian adds funds to their account via prepaid card, buys internet service. They just paid sales tax. Another North Carolinian adds funds with their credit card via the Boost website, buys the exact same thing. You just treated these two people differently. You effectively charge sales tax with one person and not on the other. I think that is a very strong argument that there's a conflict with the federal statute on not charging sales tax. Another way of thinking of it is, what if we rewrote the first element in conjunction with other services, including internet services? Would that pass muster? If we interpret that, would that pass muster with the law with respect to internet services? I would submit to you not. It would not pass. One thing I believe I heard, and we were talking about Visa gift cards, and I think hopefully this puts this issue to rest as it was issued in business court, that gift cards are outside the scope of sales. I didn't hear any argument that the Visa gift card was not subject to sales tax. I didn't hear that at all. And so I assume that the state agrees that if I get a Visa gift card, $100, I'm not paying a cent of sales tax on that transaction. So I want to be clear, it is within the scope. Retailers understand it. It is a pronouncement. It's a pronouncement in code. It's a pronouncement in sales tax bulletins, as crystal clear as you can read it. Gift cards are not subject to sales tax. To go back and insinuate to all the retailers in this state that maybe there's waffling with respect to whether gift cards are not subject would, I think, create waves in the retail industry across the state. But I don't think we need to go there, again, because this narrowly drafted statute with respect to old technology, this is a new animal, new technology. I think the appellant established that in the trial.
Thank you, counsel.
Thank you.
Thank you both. Court.
All rise.